Settled. The case is 23-50439, Dwyer versus United Healthcare Insurance. And I think we hear first from you, Ms. Green.
Good afternoon, Your Honors. May it please the Court, I'm Elizabeth Green, and I'm counsel for the appellant, Mr. Kelly Dwyer, and I request 5 minutes for rebuttal. The District Court's judgment warrants reversal on two central issues. The first being that United improperly determined that Mr. Dwyer's daughter, who goes by the initials ED because she was a minor, was medically appropriate for discharge to a lower level of care when her treating physicians opined that she could easily relapse if discharged. And the second issue, United underpaid benefits for her treatment under the plan when it did not pay rates negotiated by United's vendor MultiPlan. If the court has a preference on which issue I start with, I'm happy to indulge. Otherwise, I'll take them in order.
Maybe start with the first, just the full denial of the inpatient hospitalization.
Yes.
Because it is de novo review, so we're sort of playing medical doctor ourselves, correct?
Yes.
And I'm just going to summarize what I think the district court summarized, and then you tell us what your emphatic response would be. United had 3 reviewing doctors that said that intensive outpatient would work. Then there were some positive factors, maybe normal BMI, but if I misstate any of the facts, tell me, and no suicidal ideation. And the last big one they seemed to point to was that even the treating physicians anticipated she would go outpatient within a few weeks. So is that assembly pretty much it? And if so, what contradicts it or what outweighs it?
So not all of those facts are actually in the district court's decision.
Okay.
The latter fact is actually incorrect. The actual conversation that is in the record has United's doctor speaking with the treating physician and saying, what level of care would she be at after this anticipated pass? And the doctor responding and saying, well, we don't know. We have to see how it goes. Okay. When she gets back, we'll see how it went, which is reasonable. That's appropriate. Yeah. Because you don't want to anticipate what's going to happen when she gets back from that. I do like starting with medical necessity because it gets to the heart of why we're here. We're here about a 15-year-old girl who, at the time, had been suffering with eating disorder behaviors for a third of her life. The behavior started when she was 10, 5 years earlier. She goes into residential treatment at the provider, and she weighs 75 pounds at a height of 5'2". She's drastically underweight. And frankly, if she had continued on that path, she would not be alive. She goes into residential treatment, and it's approved for 4 months. And by the time the time where we're talking about the denial and partial hospitalization, she's gained 42 pounds. She's gained, my math isn't great, 40% of her weight back, right? She's taken her 5 months and 42 pounds to get to an average weight. But yet she's not ready to be discharged to a lower level of care, and this is why. With that weight gain, she has traded some behaviors for others. So a mark that is continually presented in the record and by her treating physicians is that she is intentionally body checking, walking funny, because now she has weight on her body, and her thighs are touching, and she doesn't like it, so she's walking intentionally in a very odd manner, so that her thighs aren't touching. These are the things that now the treatment team is trying to cope with. They're trying to cope with the fact that on just a 3-day pass, the pass that Your Honor mentioned originally, they were anticipating that for a couple weeks out. She'd go for a week. Let's see how a week is. She had tried a 3-day pass. And over that 3-day pass, she lost over 2 pounds. These passes are designed to, let's see how she does taking these skills into being home with her family, not having any treatment supervision 24/7 like she has here, not having her meals monitored. Let's see how she does. And she did not do well. She gained back that weight over the next 4 days, and United points that out. And I'm glad they point it out because that's actually the point. The point is that she was back in treatment with 24/7 supervision with all her meals monitored. And that's why she was able to gain that weight back. When we think of it took her 5 months to gain 42 pounds, if she goes home and she's losing...
So is the key feature distinguishing intensive outpatient and inpatient the ability to monitor meals? Or is that over?
Yes.
That is the key feature.
We have to understand what these treatment levels are, or none of this makes sense. So partial hospitalization is about 20 hours a week, 5 hours a day. And that is meals being monitored. Intensive outpatient, we're dropping those hours by 70%. So now she's at 3 hours a day, twice a week. And her treatment team is saying...
Well, what's the rule going forward if it's Dr. Say, Dr. Center, Dr. Blocker? They have 3 doctors that claim if we were to say it's an abuse of discretion for the plan to have relied on 3, the consensus of doctors, is there a limiting principle? And if it is that in the world of mental health you have to somehow enhance the treating physician's predicament, or is it simply this weekend pass that event alone contradicts? See what I'm asking? I'm wondering what the rule is we would announce, that an insurer is always abusing its discretion in the context of anorexia and these mental health disorders. They don't keep paying inpatient when what?
Well, we're not at abuse of discretion. This is actually de novo.
It is de novo, but we have to find that United abused its discretion in denying the benefits, correct?
No, what should have happened is that the court should have weighed all the evidence de novo, not given any weight or any discretion to United, and said, now that I'm balancing everything, what do I see?
I thought the district court did what we do independently, de novo. It just said, well, there's a consensus of doctors. They've looked. I guess that's my primary question is, speak to those 3 doctors that they consulted who all said outpatient was adequate.
Well, the district court decision actually only referred to the 1. And it's not I would say it's not quantity over quality. It's quality. We have treating physicians who've been treating her for 5 months. This is the benefit of her being at different levels of care at the same facility. They've seen her day in and day out, and they're saying, based on their clinical knowledge of where she's at and where she's been, that she's not able to do this at an intensive outpatient level of care. And if you discharge her, she could be right back here, and we're back where we started from, or worse. We want her to have the skills to move on, and frankly, that's part of their criteria. Is this going to be generating equivalent therapeutic benefit for her? And the answer was no. And there was no response given as to why, frankly. Why aren't we giving some value to the treating physicians, who are the ones who have seen her day in and day out? We don't actually have findings from the court on these points. I think it's very important to look closely at the district court decision, which vacillates between Mr. Dwyer argues, United contends, and that goes on for about 2 pages, and then we have 1 sentence that says, we're giving equal weight to Dr. Center's opinion. Well, equal weight to what? What's on the other side of the scale? We don't know. We don't have those factual findings. They don't exist in the district court decision.
Counsel, I have a question about the competing doctors' opinions. I'm looking at the letter that United sent to Mr. Dwyer, and it says, after talking with your doctor, it is reported that you have made progress and no longer need the type of care and services provided in this inpatient setting. So that's United's letter. I don't understand what this means. I realize this is or perhaps a better question for United, but it says talking with your doctor. Is that including, in your view, the United physicians? Or when it says after talking with your doctor, I assume what the plan means is the treating physicians, but clearly
Correct.
it doesn't, because I've read this record carefully, and I cannot find anything in here where one of ED's doctors said at the time of this letter, sure, go home, or go to some lower level of care, you're fine.
You are correct, Your Honor. The
Okay,
record
so
does not contain that.
So the only way to read that, in your view, is after talking with your doctor must mean your doctor are the United doctors or the independent doctors, or whatever, but somebody other than the treating physicians.
So we in the letter, I think, refers to, my reading of it,
Sure.
refers to United and United's representative doctors.
Got it.
Yes. With my time left, I do want to address the underpayment issue. I think that it's really important to understand that we are beholden to what the plan provides. The plan is the central thing that we all have to look to in these ERISA cases. And we're lucky that the plan clearly defines what eligible expenses are. Eligible expenses under the plan for a non-network benefit is based on the rate negotiated by United's vendor. We know that United had a vendor, MultiPlan. The district court was actually just said it. MultiPlan is United's vendor. Great, we've got the vendor. We know that there's a rate negotiated by MultiPlan. We know that because there's a contract that's signed between MultiPlan and the provider. We also know that because the medical claims for ED's treatment at Avalon were paid under the MultiPlan rate. Mr. Dwyer receives explanations of benefits that say, based on an agreement with MultiPlan, we are paying the medical claims. With you having no out-of-pocket costs, we're just paying the MultiPlan rate. We negotiated it, done deal. But yet he gets explanations of benefits for the mental health piece of her treatment at the same provider, and they say, we're paying 50%. No mention of MultiPlan, nothing. You can understand his confusion here. Mr. Dwyer's an attorney. He does not practice in this area of law. He writes a really thorough 4-page appeal letter pleading. Why isn't this being paid under MultiPlan? I don't understand. Please explain it to me. The plan seems clear to him. And he gets no response. And I think that's a fundamental, insurmountable problem that United has here.
It is a significant problem, but what exactly is the problem in terms of they don't respond? Doesn't that mean it's an effective denial and they get to sue? Or does it mean you win? They cannot now say how these calculations worked and what the plan coverage is. Which is it?
If you were to take the reverse, and plaintiff didn't make those arguments, plaintiff would not be allowed to make them now. So what it means is you can raise a defense, but it has to be based on what was communicated at the time. And frankly, Mr. Dwyer did put in his letter, his appeal letter, he documented phone calls that he had with United, where sometimes—
What I'm saying is, even in equity, we can't give your client coverage that may not exist, correct? So they
Correct.
can't come up with, they can't come up with a post hoc rationalization. On the other hand, somebody, us or Judge Yackel or Yackel's successor, would have to actually go through and calculate the eligible award vis-a-vis the multi-plan. In other words, no one's done those numbers yet.
It's a very easy number because the multi-plan is 19% off the billed charge.
So what happened I thought that's what I thought, but from the record, but this is a 2,000-page record, and he stops with one sentence. Judge Yackel just says no discretion. So he never gets to this.
Correct.
Okay, but you're saying it's very easy that in the end, what happened was 50-50, whereas instead what should have happened was 81% and 19?
Correct.
Why even the 19, though? I thought the 81%, I thought it was 0 for the patient.
It is.
Okay, see.
The 81% is the amount that's paid. That covers everything. There's no out-of-pocket, nothing that comes from the patient to pay. It's just a flat 81%.
If you're right, what's the relief here? Remand for him, somebody else to go through it and decide, because we can't give you what isn't covered. So we'd have to be certain your client, if you win, in other words, he's wrong that there's no discretion under the plan or these disputed documents.
Well, a win is a remand, a reversal of the judgment on both the medical necessity issue and the underpayment issue. As I said,
So with underpayment, also remand would be, if we agree with you, remand would be the correct remedy?
yes. Everything stems from the plan. The documents that are disputed, we've called them the disputed documents, are two documents. One is signed by United. I don't see any credible argument why a document signed by United wouldn't be part of the record. When every, yes.
Does that mean in all these cases, every single document in an insured's possession is automatically part of the record?
If it is part of what the plan contemplates and how benefits are determined. For example, we have sometimes a not self-insured, but an insured benefit plan. So you have the ERISA plan, and then you have an insurance policy. Would you say that the insurance policy can't be considered because it's not the plan? Well, of course not. It's referenced as this is how the plan benefits are to be paid. Here we have a direction as to the benefits are to be paid based on the negotiated rate with our vendor. Well, that anticipates you have a vendor. We have to allow evidence in of who your vendor is because you're saying that that's how you're going to pay it. A negotiated rate, the negotiated rate has to be part of the calculation.
What was Judge Yeagel's mistake? Was it just textual, his focus on the word in our discretion?
In our discretion, actually, I think there was a real convoluting of sections. We have the eligible expenses section, and we had a shared savings program section.
That is his mistake, then?
Yes, because the shared savings program section, he talks about discretion. It doesn't appear there. It appears in the eligible expenses. So it's, the wires got crossed would be my answer.
Okay, you have rebuttal time.
Thank you, Your Honor.
Bernstein?
May it please the court. Good afternoon, Your Honors. My name is Michael Bernstein. I represent United Healthcare today. As you already heard, we really have this case boiled down to two main issues. The first being a benefit claim, which I'm sure you deal with all the time. And the second is probably something you don't see very often about the multi-plan discount that Ms. Green says is owed here. I'm going to start, if it's okay with Your Honors, to go over the benefit claim, and then I'll proceed to the other issue. So I think what you see in the district court is a de novo review following a bench trial of a benefit claim. The record was stipulated, and all of the facts are there. The facts here show that this is a patient, ED, who had impressive improvement over the course of her care. She was in 4 months of residential treatment, completely covered. Nobody didn't pay for that. And then she went to partial hospitalization, which is the next most intensive level of care. And at the time the benefits were denied for continuing partial hospitalization, the record shows, and this is really beyond dispute, that the patient, as you heard Ms. Green tell you, had gained 42 pounds. She had reached her ideal body weight. She had reached her ideal body mass index. She wasn't self-harming herself and wasn't looking to harm anybody else. She was eating all of her meals. She was actively engaged in her treatment. She wasn't engaging in concerning behavior like overplating, over-exercising, staring at others while they ate, or struggling with pacing behaviors, how long it took her to eat. And so that's all in the record. And so 3 psychiatrists from United take a look at all of that during the course of the review, and each independently comes to the same conclusion, that while this patient is not completely well, she certainly needs more care, she was able and ready to step down to the next most intensive level of care, which
So
is
when the letter
intensive
says,
outpatient.
after talking with your doctor, it is reported that you have made progress and no longer need the type of care and service provided in this inpatient setting, who is your doctor in that sentence?
I believe that may be Dr. Say's letter that you're referring to, and your doctor is Dr. Glover at Avalon Hills.
So-
there was a peer-to-peer discussion between the two doctors at the initial claim review.
So I've gone through this, and I can't find any evidence at the time you denied the claim. I cannot find any evidence that ED's doctors said, sure, doesn't need to be in a hospital setting. We can do outpatient.
No, that
So
didn't
I'm going to ask you again, after talking with your doctor, I assume your doctor is one of the United hired, then who's your doctor?
I'm sorry. Are you quoting from the letter, or are you asking who is my doctor or my client's doctor?
I'm sorry, I'm quoting from the letter. So the letter that you wrote to Mr. Dwyer, says, after talking to your doctor, right, you are well, everything's fine, you're not doing anything bad. Your doctor says you don't need this care. So I'm trying to understand. I'm looking at 1331 of the record. I'm just trying to understand. It's your letter. I'm curious what it means.
That is your doctor, Dr. Glover, from Avalon Hills.
And so what is the evidence?
Your doctor.
Right. And what is the evidence that the folks at Avalon Hills thought that ED didn't need to be in this setting?
Well, I don't think there is evidence that they didn't yet.
Yeah, I'm concerned.
Yet. And let me just, I don't want to cut you off.
Well, I appreciate that, but it strikes me that yet is the answer, right? So I understand that these things evolve over time, but United is an ERISA fiduciary, right? And you only get to make the decision based on the facts. You're supposed to be making decisions that are in the insured's best interests. And I don't understand how you can say this sentence when it seems to be not true. You say, well, you're also not engaging in any concerning behaviors. Well, the record is teeming with concerning behaviors. The body checking, the thighs touching, and there's not a single thing in the denial letter where you ever grapple with the fact that she goes on a 3-day pass and she comes back having lost 5% of the 40 pounds that she gained in the facility. So how in the world can you say, well, that's not a problem?
Well, I think you have to look at the record as a whole, Your Honor, and there are extensive notes in the claim file about Dr. Say's peer-to-peer discussion with Dr. Glover and also his review. I mean, his review goes on for like 5 or 6 single-spaced pages of the record. What he's saying then when he's writing the letter, which is trying to state in a manner calculated to be understood by the recipient in layman's terms, basically, is that while, the patient has been through this course, she's ready now, based upon this improvement, to step down to the next most intensive level of care, which she had done earlier. She had stepped down from residential to partial hospitalization. And as one of your honors said during your questioning of Ms. Green, that in fact, Dr. Glover stated that the patient was they were going to start stepping her down in a week. They wanted to send her on a pass and then start stepping her down. And by the way, what she did, there is evidence that this is from the therapy notes, not from anybody's letter about whether or not the patient was well enough to be stepped down. The patient said to her therapist, Dr. Glover, that she's feeling better, that she went home, it went well, I wasn't doing this, I wasn't doing that. And so there was a lot of cause to be optimistic based upon her discussions with her therapist, as noted in the chart.
So can I ask a question? Is your view of the fiduciary standards imposed on your client by ERISA that if somebody comes in and says, hey, I feel great, and the doctor looks at the record and says, well, there's a bunch of concerning evidence about psychological behaviors, where it's the body checking or the thighs touching, funny gait, et cetera, and you've lost 2 of the 40 pounds that you gained in our facility in a 3-day pass, that you're allowed to credit the former and ignore the latter? That's the fiduciary standard? You get to take just the good and ignore all of the bad?
Well, no, and I don't think that's what happens.
So then what was, just stick with me. What was it that United did with the bad? You just told me that United can't pick just good stuff and ignore the bad stuff. And I'm asking you, what did United do with the bad stuff?
I think they acknowledge it. I mean,
Where?
let me say
Show me
this.
where it is in the letter.
in response to that question. If there was no bad stuff and there wasn't any concern about bad stuff, they just would have said, we're done, no more treatment, we're not paying for anything else, you don't need it. They didn't do that. They approved care at the next most intensive level of care, which is a minimum. It's not limited to 2 hours, every 3 days, for 3 days a week. It could be more than that. It could be a lot more than that.
How many pounds does United think that someone's going to lose at the next level of care down if she can't do a 3-day pass without losing 2?
Well, that's not necessarily true, because what Dr. Say noted and what all the other doctors noted was that this is a patient who had her first menses, and they thought that that might have had something to do with the weight loss. So there was a discussion of that, and it was gained back rather quickly. So, and she was eating all of her meals, and she was eating and in fact, there was even discussion of reducing her caloric intake with her doctor. So,
But Counsel, it's gained back because her dad wouldn't let her leave the hospital. I mean, it's an incredible thing to stand here and say, look, we recognize that she leaves for 3 days, she loses 2 pounds, but we United should get credit for the fact that she gained it back quickly. She gained it back quickly because her dad wasn't willing to do what you said, which was, let's step her down and just see how it goes. We'll just gamble with her life, I guess.
Well, I think that's a little extreme. There again, it wasn't.
I agree it's extreme, but not in a way that helps you.
It wasn't just Dr. Say. It was Dr. Center, who was not a medical director at United. Dr. Center was an independent peer review consultant, and she agreed that the patient could be stepped down. Look, there's a spectrum on which these people who have mental illness are judged. They try to make it as objective as they can. They have these level of care guidelines. There was work to be done with this patient. No one is saying that this isn't a patient that remained ill, so ill that she had to stay inpatient. This is a patient that was ready to step down. That's the whole idea. You're looking to, allow these patients back into their normal lives.
Did United ever explain anywhere to anyone why it believed that step-down treatment would be as effective as partial hospitalization?
I think it's more that she didn't have the symptomology that merited continuing care at that intensity.
But is there anything in the record that kind of lays out United's explanation or reasoning why it believed that step-down treatment would be as effective?
Well, I think it's more in the sense that she's made all of these improvements and she's ready to step down. It's not sort of there's no discussion about what's.
But there's no sort of written
future
out,
other than that.
No written out rationale or reasoning given for why United believed that step down would be as effective.
Well, no, I think that there's, on the 3 doctors' reports that are in the record, they all talk about how she's had all of this improvement, has met her ideal body weight, is eating all of her meals, has stopped doing things that were harmful. Does she still have work to do? Does she still have issues? Yes, but there's nobody saying she's going to relapse. There's a risk of relapse, is what was said, and that's a risk of any level of care. There's no guarantee that if she stayed in partial hospitalization, she was going to recover. And by the way, partial hospitalization is not 24/7 monitoring. That's residential level of care. Ms. Green said that she's being watched 24/7. She's not. She's being watched 5 hours a day, I think for 5 days a week. And so she had already stepped down from residential and had done very well, with residential being 24/7. So there's a place along the continuum where stepping down is appropriate. And in fact, Dr. Glover herself said so. She practically agreed with Dr. Say, Dr. Center, and Dr. Blocker, but she just wanted to do it a week or so later.
What's the record support for that? The doctor agreed it would be a week or 2.
Because she has notes, she has planning notes in the record.
Okay, do you have a record site for that?
I'm sorry.
Do you have a record site for that?
Yes, I can give it to you. I have to find it.
It may be in your brief.
Can I maybe give it to you after my time is up?
Yes.
Because I don't want to. I only have
I guess you're right.
6 minutes left, and I want to get to the other issue, unless you still have questions on the benefit claim.
No, I think you should cover whatever you want to cover, but that is a significant big second issue.
All right, so I think that on the second part of the claim, the multi-plan rate issue, I think Ms. Green has gotten a little ahead of herself. There's several problems with the plaintiff's claim there. So the first thing is that the records, the documents that Ms. Green is saying the court should look at to judge this claim, they're not part of the administrative record.
What is in the administrative record?
Sorry?
What is in the administrative record?
The only thing that Mr. Dwyer sent in was his letter and a copy of his insurance card.
And what in his letter appeals the denial, right?
Yes.
And what was your obligation as
They were supposed to respond to it.
Yeah, and what did you do in the response?
They didn't. I mean, what can I tell you? They didn't respond to it, but that...
Never. Have they done it today?
I'm sorry.
Have they done it today? Where it's 9 years later, have they ever responded in any way?
Well, they responded as part of the lawsuit.
What would be your best case for the idea that an ERISA fiduciary can get a timely appeal from an insured plan participant and then ignore it and complain about the absence of an administrative record? I've never heard or seen an argument like that anywhere. What would be a case that would say that?
Your Honor, a case would be that the plaintiff bears the burden of making their claim, and they have to submit evidence that they think would sway a reasonable mind. Just because there was a mistake made here, and as the Supreme Court said in Conkright versus Frommert, even administrators of benefit plans make mistakes from time to time. It happens. They made a mistake here, but that doesn't mean that the record is left open for anybody to submit things. And let's be clear, it wasn't submitted in discovery in this case either. It wasn't part of the plaintiff's initial disclosures. It was never produced or identified in the discovery part. It wasn't even made a part of the pretrial briefing. The first time we saw it was in a reply.
What's your position here? Because Judge Yackel just ruled that they would have had discretion not to give the multi-plan rate discount. But it sounds to me like you're denying there was any even eligibility for it.
Well, there's two. I'm saying that we don't even get to the discussion of whether you get to the contracts because they're not part of the record, as this court held in the Vega case.
Number one, Judge Yackel didn't rule that way, I don't think.
Yes, he did.
I thought he said, I've looked at the plan, I think you have discretion to give the discount or not.
No, he said that was when he went on to find that even if I looked at this, because he granted our motion in the district court to strike the contract, which plaintiff offered us on their reply.
There were other employees at this facility that were saying that your insureds, other patients with your insurance, were getting the discount rate.
There's no evidence of that in the record or anywhere. And Mr. Dwyer rather did not submit any evidence of him receiving any other claims paid pursuant to multi-plan. It's literally not in the record. It's not even part of the disputed documents. It's just not there. What Judge Yackel did below was he granted our motion to strike the authenticating affidavit or declaration.
You're saying my memory from this record that there are other employees that said that insureds of yours, that is just an incorrect memory of mine.
That's just something that Mr. Kelly said without any proof to back it up. Mr.
Kelly.
I'm sorry, his name is Kelly Dwyer, and I keep on confusing his name. Mr. Dwyer said it in his appeal letter, but he didn't. There's no actual proof of that to back it up.
But it's in the administrative record because that's the only document in the administrative record because your client failed to adjudicate the appeal.
Okay, so that takes him only so far. Right? You have to actually prove this up somehow.
How in the world is he supposed to litigate the appeal against himself? Like, was he just like yelling into the abyss? I appeal. What else is he supposed to say?
Well, Your Honor, as I think Your Honor, Judge Higginson said, that there's no response to the appeal. Actually, there was a response acknowledging it, and then they never actually adjudicated it, which is a mistake. What can I say? So they've exhausted their administrative remedies. That's what the court would hold. And they have what they submitted. There was nothing stopping Mr. Dwyer from putting in proof to support this during the litigation, but he didn't. I'm saying again because I think it's worth noting that we didn't see it until the reply brief on
Let's
the
assume that
pretrial
we think, given the truncated form of the record, that there was a negotiated rate out there. Let's just assume that.
Okay.
Then what? Would
Because
you say, would you
this isn't-
defend Judge Yackel's interpretation?
Yes.
that with a negotiated rate,
Yes.
somehow you still have discretion to ignore the negotiated rate?
No, because I think that's a misreading of the contract. The shared savings provision, and multi-plan is a shared savings provision, is to see if you can lower the eligible expense. Right? So, and if it does, then you use it, and if it doesn't, then you don't. It's as simple as that.
Okay.
That's the fiduciary's obligation under the
But
plan.
no one's done those calculations.
Well, look, it's simple math. I mean, the benefit here was paid at 50%. I see I'm almost out of time.
Oh, no, go ahead.
The benefit here was paid at 50% of billed charges. Why? Because that is the payment rule for out-of-network providers like Avalon Hills. It's supposed to be 110% of the Medicare rate if there's a published rate. There is no published rate for partial hospitalization under the Medicare.
But why wouldn't it be less for the Dwyer family if the multi-plan rate was, we'll pay 81%, you actually don't need to pay anything? Or just 19%, that's less than 50. Isn't that simple math?
But that's not the negotiated rate that we're talking about. We're talking about
We don't know because you never told anybody anything.
And I'll go a step further and say,
there was no decision, but that doesn't change the contract.
what I don't understand is, so I appreciate the conversation you're having with Judge Higginson, but I don't understand why you're not stopped from every single word that just came out of your mouth, because you could have said everything you just said in response to his appeal. Like the whole point of if you flip the roles, right? If you flip the roles and the insured is the one who is forfeiting the right to participate in administrative appeals, we kick those people out of court all the time because that's what ERISA requires. The roles are reversed in this case. I have never seen an ERISA plan fiduciary ignore its own administrative appeal process. Everything you just said to Judge Higginson, you could have written back to Mr. Dwyer, and then he would have known where he stood with respect to the thousands and thousands of dollars that he's spending on behalf of his daughter. But because you never responded, he's totally in the dark. He has no clue where he is with billing, why he's being billed the way he is, and ERISA imposes all kinds of obligations on you to answer him. So I don't understand how you can come into court and say, well, number one, we get the benefit of the fact that the record is silent because we never participated in it, and number two, here's our justification for why we did what we did. You could have done that in the appeal.
Well, Your Honor, what I would say to that is that it's not I don't believe that the rule is in this circuit is that it's a death sentence on the claim that you just have no ability to defend it. I believe that the rule is that you've deemed exhausted, and the claim is deemed denied, so you could proceed with your litigation. But the question then becomes, would you be entitled to that? You have to go back to the contract, the base contract. I see my time is up.
You could finish, but you say, so if we have to do the work ourselves, we go to the back. You said the math is just simple. Could you?
No, I would say that you would need to actually you would have to actually litigate the issue. If you're claiming that you're entitled to payment under this contract, it would...
Just say it's simple, because it does sound a little bit like you get a do-over. If you don't have to answer then, comes up now, we've got to figure it out. But you win, because it's simple math. But I haven't quite understood why the math is simple.
Because the plan talks about payment to non-network providers.
They don't get the benefit of the discount, period. That's the simple math.
They don't get the benefit of the discount because it doesn't reduce the eligible expense.
Okay.
That's why.
Thank you, counsel.
Thank you.
Buttle? Ms. Green?
Thank you, Your Honors. Starting where you just left off, United chose not to engage with my client during the appeal process. It was their choice. They were fiduciary. They did have a responsibility to protect participants and beneficiaries first. United didn't give any evidence for the underpayment and can't do so now. There's a reason that ERISA requires, and Vega in that decision talks about how the motivating concern here is that our procedural rules encourage the parties to resolve their disputes at the administrative level. What if all plans ignored every appeal that came to them and came into court and said, well, we get a defense, we get to put our arguments in now?
This is the Judge Oldham question. Yeah, what's good for the goose is good for the gander.
Exactly.
remembering that there was employee testimony that other United insureds were getting the discount? Is that just me wrong? Is that only in the Dwyer?
Yes, I believe that was in Mr. Dwyer's letter, but also
There were no employees that said that?
there were no additional information other than Mr. Dwyer's letter. But frankly, we don't need to look to other employees because we can look to Mr. Dwyer's own explanations of benefits that are in the record because United put them in the record that show that he got the multi-plan discount agreed rate for his medical claims. I want to be clear that the denial letter is what is before the court, the district court, to consider. The internal notes are not because they were not communicated to the claimant. So as
Back on the first issue?
back on the first issue, sorry to jump around. And what the denial letter told my client is that his daughter was better, that she was 100% of her weight, that she was eating her meals, which of course she was eating her meals because she's getting supervision at all her meals, so how much do we credit that? And that you're not at risk of harming yourself or others, which the last one I think is a throwaway because that wasn't a reason when they were approving the benefits, so why would it be a reason for denying the benefits? Those are the factors that should have been considered by the district court. The provider, the statements from the provider are that she could easily relapse if she drops to this lower level of care, and it will be difficult for her to maintain this weight at an intensive outpatient level of care. That's the information that we have from the treating physicians. They absolutely did not suggest that she could go to a lower level of care in a couple weeks. As part of a treatment plan, there always has to be, what would discharge plan be? What would it look like? For any patient, a cancer patient, whoever, there has to be some discharge plan written into a treatment plan. And the discharge plan, whatever point it would be intensive outpatient because they don't want to drop her to just nothing. You go home and see a therapist once a week.
So if you were writing this decision for you, because we are exercising somewhat of medical judgment ourselves, what would you say about doctors like Say and Center, who said she was ready to step down, and it's a terrible illness. On the other hand, this young woman has gotten back into the BMI range, and she's not showing any signs of being suicidal. So is there a limit? Do you understand what I'm looking for? A limiting principle? Or are we basically saying all these insurance companies will have abused their discretion when they see a profile like ED, normal weight range, they can never step her down? You see my concern?
Every patient with a mental illness needs to be taken where their individual presentation. It is a gross misstatement to generalize, I'm not saying that Your Honor is doing that, but to generalize any particular eating disorder patient and compare with somebody else.
But
You can,
a lot of these cases, so your case is compelling that there was an abuse of discretion because of what single fact would you point to? The 2 pounds on the weekend pass, the treating physicians simply know her better.
yes, both of those, both of those. The fact that the weight, which I know is a big consideration here, but she doesn't have a physical illness. She has a mental illness, and the weight is representative of where she got with this mental illness that makes her want to lose. She's still saying in the record at the time of the denial that she's struggling with not using her eating disorder behaviors because she wants to be thin again.
So
This is still her mindset. This is, yes.
then let's say you're right and the denial was incorrect. For how long? Because the family kept her in for 6 weeks.
She's discharged September 11th of 2015.
But you would say your client's entitled to that? Or
Yes.
Were
Yes.
any of her treating physicians saying, we think we need that amount more time?
Well, at that time in late July, we don't know exactly when she's going to be discharged. That's true. But United wasn't saying, well, we're denying it for the next couple weeks, then let us know. They're saying for future benefits, they're denying.
Okay, great.
I'm out of time, and I thank you.
Thank you both.
Thank you for your time.
You got a record site.